Counsel ready? This is for Mitchell. Calling case number 210-62510. People of the state of Michigan versus Matika Mitchell, aka Matika Monet Mitchell. Counsel. You're muted. Your microphone's muted, Attorney Stevenson.
Thank you. I apologize, Your Honor. Janice Stevenson appearing on behalf of Matika Mitchell. She stands mute, waives the reading of the information, asks the plea of not guilty, enter on her behalf. Ms. Mitchell has been advised of her rights, Your Honor.
A not guilty plea will be entered on your client's behalf. Formal reading is waived as the bond.
Thank you, Your Honor. Ms. Mitchell.
We lost your volume. We lost your volume, Attorney Stevenson.
Okay, let's try it again.
Very good, right there.
Okay, Ms. Mitchell, Your Honor, is 25 years old. She has lived in this community for her entire life, Your Honor. She does have 2 minor children that are in her custody. She lives with her children as well as with a younger sister here in the city. Ms. Mitchell would have absolutely no contact directly and indirectly through third parties with the complaining witness in this matter. It is my understanding that she needs to have absolutely no contact with that individual, or I believe with the location of the alleged offense, Your Honor. Ms. Mitchell is asking to be released on personal bond.
Thank you, counsel. The court heard the representation of counsel as to the community family employment ties of one Ms. Mitchell. The court would note that the underlying charges are very serious and they are assaultive on their face. The court will further note it does not have a prior case history for Ms. Mitchell, nor a prior criminal history. There's no indication she's a flight risk or a general danger to the community. However, this court does have serious concern for the safety of DeAndre Brown, and that must take precedent. We are still in a pandemic. The court did read the investigator's report. It does give this court some pause and concern for DeAndre Brown's safety, that a knife was allegedly used and actually stabbed the complaining witness. So there will be no contact with the complaining witness. Do you understand, Ms. Mitchell?
Yes.
No contact means exactly that. Nothing face-to-face, nothing verbally, nothing in writing, nothing through social media, nothing through a third party. Do you understand?
Yes.
Even if you are in the same public space and you might think you have every right to be in that public park or retail store, if Mr. Brown is in that same public space or public park or retail store, you have to leave immediately. Do you understand?
Yes.
Even if Mr. Brown reaches out to you, you need to not to respond. You cannot respond back. Do you understand?
Yes.
As well, you are not to possess, purchase, use any firearms or weapons. Do you understand?
Yes.
What's the employment situation again of your client?
Your Honor, Ms. Mitchell is caring for 2 young children. She's seeking employment, but not regularly employed at this time, Your Honor.
These are very serious offenses. There will be a GPS tether in place. The court is going to enter a $50,000 personal bond, $50,000 personal bond. No money needs to be released today. GPS tether.
Excuse me, if I have a charger in my apartment, I'm gonna stay there.
GPS tether. She will be allowed to go to any type of medical appointments for the children. She will be able to go to any school appointments for the children if they're in-person school. Next court date is a probable cause conference on December 20th, probable cause conference December 20th, preliminary exam January 4th. I believe your client was trying to say something while I was talking. That was very rude, first and foremost. Second thing, I would advise your client to remain silent. because anything she says can and may be used against her. We are live on YouTube and live via Zoom. She has an attorney that she can talk through. But I will give Ms. Mitchell this opportunity to speak if it's relating to the bond and the bond only. She is not to discuss anything that relates to this case. Ms. Mitchell, do you have something you want to say?
Yes, I apologize for interrupting. I had wanted to say, if I'm on a tether, I can't stay at my apartment complex. And that's the only place that
And
I have.
why is that? Is there something in your lease that says specifically that if you're on the tether, you can't live in that place or reside there?
Yes, yes.
Because I've never heard of that, but okay. I'm at a quandary then, counsel, because without this GPS tether, I have no way to make sure that number one, Mr. Brown's safety, which I have foremost concern, and then also because I would like to track Ms. Mitchell's whereabouts as she is, if she is released, and then two, that would be a constant reminder for her not to have any contact with Mr. Brown. If what she indeed is saying is true, and it's very difficult to find another place to live, give me one moment.
Thank you, Your Honor. And I know the court has already done so, but I would just knows this already, but I would just remind the court that we are not aware of any prior criminal history for Ms. Mitchell, Your Honor. And I am thankful that the court is taking into consideration what she said, that the requirement of a GPS tether would actually render her homeless, Your Honor. Her and her children.
Yes, and so this court right now, I don't know, counsel. Without that GPS tether, this court has some serious concerns about Mr. Brown's safety. This is a very fresh case and incident.
Yeah, it is,
A
Your Honor.
weapon was allegedly used and an injury as well. This court has some serious concerns about his safety. The only other option is then a monetary, which again, I would have to place the monetary in such a way that if she violates, obviously, she would lose that money, but also, so this is what the court is going to have to do, given that the GPS tether is not an option in this case. I take it there's no other place that she may be able to move with her two children. With that, this court is going to enter a $25,000, 10%, $25,000, 10%. 10% is going to be needed, $2,500 for the release of your client. The court feels that that is very reasonable. The court was actually considering a $50,000 at 10%, just to let you know. But because of the situation, the employment situation, the court did reduce it. The court is not going to reduce it any further, counsel, even though you may have another argument, because again, the court has to make sure that Ms. Mitchell shows up for her court appearances and takes very seriously there's no contact order. And if she or somebody that puts up this monetary bond knows that they could lose that money if she violates, I think that would be all the indication that's needed. And so to help prevent her from violating the order. So it stays in place. Again, probable cause conference, December 20th, preliminary exam, January 4th, 2022. Anything further, counsel?
Your Honor, would the court consider maybe $15,000, 10%, whatever amount of money it is going to be quite significant, but she might be able to come up with that bond. I think that $25,000, 10% is going to render her incarcerated, Your Honor. But we do thank the court for its consideration, for hearing what she has to say about the tether. Just that if we could get it down to 15,000, 10%, maybe somebody could get that up for her.
I appreciate the further argument for your client, but again, this court, as stated, is not reducing it any further. Again, my first thought was 50,000, 10%, but given the circumstances, the court did reduce it. Again, if she was able to have the GPS tether, it would have been a personal bond. So under these circumstances, the court is going to stay at 25,000, 10%. We're all set. Thank you.
Thank
Have a
you,
good
Your
day,
Honor.
Ms. Mitchell. State your name, please.
Selena Richardson.
Selena Richardson. Okay, thank you. Looks like I have two cases for Selena Richardson. I'm gonna call both cases, counsel.
Thank you, Your Honor.
All right, calling first case 2162506. People of the state of Michigan versus Selena Richardson, and calling case number 200600953. People of the state of Michigan versus Selena Richardson. Counsel, your appearance.
Janice Stevenson appearing on behalf of Selena Richardson. Your Honor, could the court read the information for the second case, which the court did call, please?
Okay, that's the one, case number 200600953. As it relates to that case, the information reads, count one, defendant one, controlled substance delivery manufacturing, less than 50 grams. Count two, defendant one, controlled substance delivery manufacturing, less than 50 grams. Count three, defendant one, controlled substance possession, less than 25 grams. That's it, those three.
Thank you, Your Honor. And with regard to the remaining matter, we would waive the reading information. As to both matters, Ms. Richardson will stand mute. We ask that a plea of not guilty be entered on her behalf. Ms. Richardson has been advised of her rights, Your Honor.
Thank you, counsel. Not guilty plea will be entered on both cases. Formal reading will be waived on the case ending in 2162506. As it relates to bond, this court will let you know there is a capious bond for Ms. Richardson, counsel, 5,000 cash surety. That's on the case number that was read into the record, 200600953. 5,000 cash surety on that one. I'll hear if you have any information from the judge on that case, but also I'll hear bond as to the other matter.
Thank you, Your Honor. We do not have permission at this point to remove any capious and reduce any capious bond. As to the remaining matter, Your Honor, Ms. Richardson is 48 years old. She is seeking employment at this time, Your Honor, did graduate from a local high school. We would like the court to be aware of the fact that Ms. Richardson has been diagnosed with asthma and bronchitis, two conditions which we consider to be particularly dangerous for a person to remain incarcerated at Wayne County Jail during this time of COVID. We would accordingly ask that the court consider releasing Ms. Richardson on nominal.
Thank you, counsel. The court has heard the representation of counsel as to the community, family, employment, and medical condition of Ms. Richardson. Did he see we can mark this file as medical, mark this file as medical? The court would note that it has a prior criminal history for Ms. Richardson. Also, it has an additional matter that is before this court, and it has a capious attached to it. So there is a capious history for Ms. Richardson. So there is a caution that this court will have as it relates to Ms. Richardson being a flight risk, as well as this prior criminal history that she has. Let's see. Gives this court some pause, concern, even though it's non-assaultive, for the general danger of the community. So it gives this court some pause. As it relates to case number 2162506, court did read the investigator's report. The underlying charges are serious. The one specific is serious and assaultive on its face. Court is going to enter a monetary bond in that case as well. 50,000, 10%, 50,000, 10% as it relates to that case. That's case number 2162506, 50,000, 10%, so 5,000 needed to be released. There's a capious bond for the other matter, 200600953, 5,000 cash surety, which also another 5,000 would be needed on that case to be released. For your court dates, I have one court date. This must be for both matters. One court date, both matters. Probable cause conference, December 20th. Probable cause conference, December 20th. That's at 8:30. Preliminary exam, January 4th, 2022 at 8:45. Preliminary exam. Anything further, counsel?
No, thank you very much, Your Honor.
You all set, Ms. Richardson. Have a good day.
Thank you, you too.
Thank you.
These are the mayors.
State your name for the record.
Aisha Muhammad.
Aisha Muhammad, thank you.
You're
We also
welcome.
have two cases for Ms. Muhammad. First case number is 2162506. People of the state of Michigan versus Aisha Muhammad. And we also have case number 200600953. People of the state of Michigan versus Aisha Muhammad. Counsel.
Janice Stevenson on behalf of Aisha Muhammad. Your Honor, could the court please read the information for the second case the court has referenced?
That is case number 200600953. People of the state of Michigan versus Aisha Muhammad. The charges are count 1, controlled substance, delivering, manufacturing less than 50 grams. Count 2, controlled substance, delivery, manufacturing less than 50 grams. Count 3, controlled substance, possession less than 25 grams. Habitual third notice. Oh, also count 4, controlled substance, possession less than 25 grams. Habitual third notice for this client, for your client. Looks like a 1998 case. Delivery attempt, possession with intent to deliver less than 50 grams out of recorder's court. 2003 case, manslaughter, conviction, Third Circuit. Court has some concerns, obviously, with that one being assaultive. Also, Ms. Muhammad, I would advise you not to speak at this time. Thank you. Also, as it relates to additional prior criminal history, looks like a 2001 attempt delivery, 2004. Court's already read that. The new charge, additional charge, excuse me, would be 2012, breaking and entering out of the Fourth Circuit, breaking and entering 2012 case. Court will note that yes, some time has elapsed from those felony convictions and this charge today. However, we do have some assaultive mixed in with some non-assaultive, and the court will take that under consideration to help determine a reasonable bond for Ms. Muhammad in this case. Also, the court will note that it has a capious bond, 5,000 cash surety, 5,000 cash surety for Ms. Mohammed in the 200600953 case. Counsel, is there anything else as to bond for Ms. Mohammed?
Your Honor, we would, as to the remaining matter, waive the reading of the information. She'll stand mute in both cases. Request that pleas of not guilty enter on her behalf. Ms. Mohammed has been advised of her rights, Your Honor.
Thank you. That not guilty plea will be entered on behalf of Ms. Hamid for both matters. And the formal reading is waived on the case number 2162506 matter, specifically to bond.
Thank you very much, Your Honor. Ms. Mohammed is 42 years old. In the instant matter, Ms. Mohammed continues to seek employment, Your Honor. She did graduate from a local high school. She's indicated she does not have any money to post bond. She would have absolutely no contact with the complaining witness in this matter. She does understand the importance of returning to court despite the capious in the other matter, Your Honor. She understands that failure to keep all court dates puts her at risk of incarceration. Ms. Mohammed does request release on nominal bond, Your Honor.
Thank you, counsel. Court has heard the representation of counsel as to the community, family, employment ties of one Ms. Mohammed. Court would note that on the case number 200600953, there is a capious bond, 5,000 cash surety. This court has no discretion to modify or change that bond at this time, so it will stay in place, $5,000 cash surety to be released on that case. In the matter, case number 2162506, this court has serious concerns about the general safety of the community, as well as the complaining witness, Jonathan Elmore. So there'll be a no contact order for Jonathan Elmore. You are to have no contact with Jonathan Elmore. Do you understand that, Ms. Mohammed?
Yes, sir.
Besides the no contact order, given the serious nature of the charges that she's facing, as well as the prior criminal history with non-assaultive and assaultive charges being mixed in together, even though some time has elapsed from those felony convictions and this date, this court still has some general concern for the safety of the community. This court is going to enter a $75,000 10%, $75,000 10% bond in this particular case. This court has to be more concerned about the safety of the community than the liberty of Ms. Mohammed at this time. So if she's able to make bond, great. If not, this court wants to make sure that Mr. Elmore and the general safety of the community takes precedent. The court date for Ms. Mohammed is probable cause conference December 20th at 8:30. That's probable cause conference December 20th in front of Judge Jones. Preliminary exam January 4th at 8:45. January 4th at 8:45. If she so chooses. Anything further, counsel?
No, thank you very much, Your Honor.
You're all set, Ms. Mohammed. Have a good day.
Go, sir. Behind.
Okay, we got Rose Mills and Demetria Johnson.
Ready on all those.
Demetria Johnson. Johnson.
You have a Johnson on your
Demetria Johnson, Demetria Johnson.
Mhm. Mhm. What's up?
Good afternoon, state your name.
Demisha Johnson.
Demisha Johnson, calling case number 2162508, people of the state of Michigan versus Demisha Johnson. Counsel.
Janice Stevenson on behalf of Ms. Demisha Johnson. She stands mute, waives the reading of the information as to the plea of not guilty entered on her behalf. Ms. Johnson has been advised of her rights, Your Honor.
Not guilty plea will be entered on your client's behalf. Formal reading is waived. Ask to bond.
Thank you, Your Honor. Ms. Johnson is 22 years old. I do not believe we have any criminal history, Your Honor, or any prior arrests even. Ms. Johnson does have two very young children, a 10-month-old baby and a 2-year-old child as well, Your Honor. Would have absolutely no contact with the complaining witness in this matter, has advised us that she would return for all future court dates. Ms. Johnson does not have any money to post a bond, Your Honor, and is requesting release on personal bond.
Thank you, counsel. Court has heard the representation of counsel as to the community, family, and employment ties of one Ms. Johnson. The court would note that these charges are very serious. They are assaultive on their face. This court further notes it does not have a prior capious history for Ms. Johnson, no indication that she's a flight risk. This court does not have a prior criminal history for Ms. Johnson, no indication that she's a general danger to the community. However, this court does have concern with the safety of Mahalia Simpson. This court did read the investigator's report, and this court is must pause and use all form of caution in terms of as it relates to Ms. Johnson and these allegations, which gives this court some concern. I do believe that she knew the complaining witness, so that makes it a little different than if this was just random. However, Ms. Simpson's safety must take precedent over the liberty of Ms. Johnson in this particular case. When reading this report, it appears and allegedly that your client took the action completely to Ms. Simpson. It was outside Ms. Simpson's residence. Ms. Simpson's car was vandalized. Allegedly, your client entered Ms. Simpson's home. Allegedly took a pair of scissors, cutting underneath the right eye of Ms. Simpson. Those are some very serious allegations that your client is facing. And this court, quite frankly, has concern about Ms. Simpson's safety. So first and foremost, there will be a no contact order in place. Ms. Johnson, you are to have no contact with Ms. Simpson. And no contact means exactly this: nothing face-to-face, nothing verbally, nothing in writing, nothing through social media, nothing through a third party. Do you understand?
Yes.
Even if you find yourself at a public location, a public park, or a retail store, and you're thinking to yourself, you have every right to be at that store or location. If Ms. Simpson shows up and she's at that same location, you are the one that has to stop shopping. You're the one that has to leave the park. You must leave that public space. Do you understand?
Yes.
You are not to possess, purchase, use any firearm or weapons. Do you understand?
Yes.
I believe you said your client is not working. Is that correct?
Yes, that is correct, Your Honor.
There will be a GPS tether. GPS tether is going to be in place for number one. So this court can monitor your whereabouts, Ms. Johnson. Court wants to keep tabs on you, quite frankly. And it's going to be a constant reminder that you are to have no contact with the complaining witness, Mahalia Simpson, and hopefully will keep you from picking up any new allegations. Do you understand?
Yes.
Now, since you do have children, I will allow you to go to back and forth to medical appointments and to the store. Actually, there'll be no restrictions on this GPS tether, no restrictions. so you can move about freely. However, as I mentioned before, if Ms. Simpson is the same place you are, you have to remove yourself quickly from that location. Do you understand?
Yeah.
Court is going to enter a $50,000 personal bond, $50,000 personal bond in this particular case. Next court date is a probable cause conference, December 2nd. Preliminary exam, January 5th. Probable cause conference, December 2nd. Preliminary exam, January 5th. Is there anything further, counsel?
No, thank you very much, Your Honor.
I believe this is in front of Judge Williams. You're all set, Ms. Johnson. Have a good day.
Thank you.
Well,
That's the last mail. Just put that over the mails.
State your name.
Rose Mills.
Rose Mills, calling case number 2162504, people of the state of Michigan versus Rose Mills Council.
Janice Stevenson, on behalf of Ms. Rose Mills, waives the reading of the information, stands mute. As to the plea of not guilty, entered on her behalf, Ms. Mills has been advised of her rights, Your Honor.
Not guilty plea will be entered on your client's behalf. Formal reading is waived as to bond.
Non-assaulted, Your Honor. Ms. Mills does have significant ties to this community. She's been working as a district manager at a local restaurant, has some college under her belt, does understand that she needs to abide by all court orders, specifically that she should not be in possession of any weapons and that she should keep all court dates, requesting release on personal bond, Your Honor.
Thank you, counsel. Court has heard the representation of counsel as to community family employment ties of one Miss Mills. The court would note that the underlying charge is non-assaultive on his face. Court further notes it does not have a prior capious history for Ms. Mills. No indication she's a flight risk. Court does not have a prior criminal history for Ms. Mills. No indication she's a general danger to the community. Again, we are still in a pandemic. This is a non-assaultive matter. Ms. Mills, you are not to possess, purchase, use any firearms while this case is ongoing. Do you understand?
Yes, Your Honor.
Court's going to enter $3,000 personal bond, $3,000 personal bond. No money is needed to be released today. Next court date is probable cause conference, January 20th, 2022, in front of Judge McConicle. January 20th, 2022 is at 8:30 a.m. Preliminary exam, January 27th, 2022, if you so choose, at 8:45. Anything further, counsel?
No, thank you very much, Your Honor.
All right, thank you. You're awesome. I think that's, thank you. I think that's it for the females, DDC. Ready to move over to the male side, DDC? DDC, I think we're all set on the female side.
beg your pardon?
Ready to move to the males?
Yes, give me a minute, let me put the females away, then I'll meet you over there.
All right, understood. Signing off on the females.
Yes, sir.
Hey, Corporal Gamble. This is Magistrate Johnson, trying to reach Corporal Gamble. Be right with you, DDC. State your name, sir.
Abdullah Sanders.
Thank you. Okay, ready, Counsel on Sanders?
Ready, Your Honor.
All right, it looks like I have two cases for Sanders as well. And DDC, just to make you aware, I do have two retained matters after we take care of Mr. Sanders. Derek Gilliam and Kamari Bell both have retained counsel. I'll bring them in once we get done with Sanders. All right, calling case number 2005720, people of the state of Michigan versus Abdullah Sanders, and calling case number 210-60816, people of the state of Michigan versus Abdullah Sanders. Counsel.
Janice Stevenson on behalf of Abdullah Sanders, he stands mute. Waive the reading of the information. Also, please of not guilty. Enter on his behalf. Mr. Sanders has been advised of his rights, Your Honor.
Okay, stay in that last position you were in so we can hear you clearly. Probably right there.
Okay.
Not guilty plea will be entered on your client's behalf. Formal reading is waived. As to bond, and let me just make you aware, counsel, on the case number ending, or no, I'll give the full case number, 2005720. There is a capious $20,000 cash surety, $20,000 cash surety on that case. Oh, and also, I'm seeing also $20,000 cash surety on the most recent case, case number ending 21, case number 210-60816, 210-60816. I have two 20,000 cash surety bonds for your client.
Understand,
So
Your Honor.
if you do not have discretion at this time or anything from the judge to change these capious bonds, they'll go into effect.
I do not at this time, Your Honor.
All right. What that means, Mr. Sanders, is that you failed to appear at a previous court date on both of these matters. When you did, sir, a $20,000 cash surety bond went into effect because you missed your court dates. So this court does not have discretion to modify that that cash surety bond. So both will go into effect. You have two $20,000 cash surety bonds, one on each case. Your next court date is going to be the same. Probable cause conference, December 21st, 2021 at 8:30 in front of Judge Williams. Preliminary exam, January 5th, 2022 at 8:45 in front of Judge Williams. That's on both matters. There's nothing further, counsel. You're all set, Mr. Sanders.
Thank you, Your Honor.
Thank you. Okay, DDC, again, we have retained Derek Gilliam and Kamari Bell.
Good morning, or good afternoon, Your Honor, now.
Yeah, it's afternoon now, so I'm not sure whose client is coming first, but I did ask for both clients to come out.
Okay, thank you, Your Honor.
You're welcome. Good afternoon, sir. State your name.
Derek Gillen.
Derek Gilliam, okay. Calling case number 210-623-61. People of the state of Michigan versus Derek Cortez Gilliam. Counsel.
Good morning, Your Honor. Attorney Scott Colassa standing in for Attorney of Record Brent Jaffe on behalf of Derek Gilliam, who is present via Zoom from the DDC.
Thank you. And as to formal reading, or any type of plea?
Your Honor, we waive formal reading of the charges and stand mute.
Thank you. The not guilty plea will be entered on your client's behalf. Formal reading is waived. As to bond.
Your Honor, Mr. Gilliam is a 19-year-old man who has just had his first child just mere 4 days ago. He has tremendous family support in the city of Detroit and is a lifelong resident of Wayne County. He has retained counsel and did voluntarily surrender yesterday with Mr. Jaffe to the DDC. It is for that reason we ask for personal bond or any reasonable bond with a possible condition of house arrest or tethering.
Thank you, counsel. Court heard the representation of counsel as to the community family employment ties of one Mr. Gilliam, and I guess this is Junior, Derek Cornell Gilliam Jr. Court would note that these are very serious charges, assaultive on their face. Court does have some general concern with the general safety of the community as it relates to these allegations. The court would note, though it does not have a prior capious history for Mr. Gilliam Jr., there's no indication that he is a flight risk. And this court does not have a prior criminal history for him. But with the nature of this charge and this charge against him, this court does have some serious concern with the general safety of the community. Court does understand that he has retained counsel, but in this particular case, a monetary bond is going to be issued, given this court feels that the general safety of the community is more important than it must take precedent over your client's general safety. Court's going to enter a $100,000 cash surety, $100,000 cash surety in this particular case. Next court date is a probable cause conference, December 20th, 2021, December 20th, 2021. That's in front of Judge King. Preliminary exam, January 4th, 2022, January 4th, 2022. There's nothing further, counsel. We're all set.
Nothing further, Your Honor. Thank you.
Thank you. Have a good day, sir.
Okay.
State your name, sir.
Kamari Bell.
Kamari Bell, calling case number 210-62507. People of the state of Michigan versus Kamari Bell. Counsel.
Good afternoon, and may it please the court. My name is Adam Clements, P number 77233, appearing on behalf of Mr. Bell. Would you state your name for the record, please, sir?
Kamari Bell.
As to the formal reading or plea?
As to the formal reading, Your Honor, we'd waive the formal reading of the information, ask that you enter a plea of not guilty on this behalf.
Thank you. Not guilty plea will be entered on your client's behalf. Formal reading is waived. As to bond.
Your Honor, as to bond, albeit, and I know that the court can see that my client does have a pending criminal case. I would just submit in this particular case, Your Honor, that this is a non-violent, non-assaultive offense, that Mr. Bell has always showed up for all of his court appearances from the moment that I represented him. He's presumed innocent on both cases. We're asking that the court set a reasonable bond. I'm not asking necessarily for a personal bond, but I would ask for a reasonable bond. He's a lifelong member of the Detroit metropolitan area. All his family lives here. He has an active mother who's been very close in ensuring that he complies with all conditions of his bond. This is an unfortunate incident, and we look forward to dealing with it. Thank you.
Thank you, counsel. Court heard the representation of counsel as to community family employment ties of one Mr. Bell. Court would note that this specific charges is non-assaultive on his face. Court would further note that it does not have a prior capious history in front of it as it relates to Mr. Bell. No indication he's a flight risk. As it relates to any other matters, this court would take that under consideration as it determines a reasonable bond in this particular case. First off, you gotta have no weapons. So, Mr. Bell, you cannot purchase, have in your possession, or use any firearm or weapons. Do you understand?
Yes, sir.
Court is going to enter a 10,000, 10%, 10,000, 10%. In this particular case, $1,000 will be needed to be released. Next court date is probable cause conference, January 20th, 2022, in front of Judge McConicle. Preliminary exam, January 27th, 2022. If he so chooses. Anything further, counsel?
No, Your Honor, thank you.
Thank you. You're all set, sir. Have a good day.
All right.
Have a good day, everybody. Nice to see you.
Thank you, Attorney Clemens. You too. State your name, sir.
Trayon Ridgeway Taylor.
Ridgeway Taylor, thank you. Calling case number 210-62502. 2162502, people of the state of Michigan versus Trayon Ridgeway Taylor, counsel.
Janice Stevenson, on behalf of Trayon Ridgeway Taylor, he stands mute, waives the reading of the information, asks that a plea of not guilty enter on his behalf. Mr. Ridgeway Taylor has been advised of his rights, Your Honor.
Not guilty plea will be entered on your client's behalf. Formal reading is waived. Ask to bond.
Thank you, Your Honor. I know there's a second offense notice on this matter. The instant charges are non-assaultive, as well as that prior conviction, Your Honor. Mr. Ridgeway Taylor is 20 years old. He is employed at this time, Your Honor. I think he's been on his current job just about a year. He does have some college under his belt. He actually is expecting a baby. His significant other is expecting a baby in about 3 weeks, Your Honor. That, I believe, is incentive for Mr. Ridgeway Taylor to keep all future court dates and to abide by other orders of this court. We would ask the court to release him on personal bond.
Thank you, counsel. Court heard the representation of counsel as to community family employment ties. One, Mr. Ridgeway Taylor. The court would note that the underlying charges are non-assaultive on their face. Court further note it does not have a prior capious history, no indication he's a flight risk. Court does have a prior criminal history of 2021 or August 26, 2021, felony conviction for carrying a concealed weapon out of the Third Circuit. And here we are again with the allegation of carrying a concealed weapon. I just don't understand, counsel, why we would be here in December facing this type of charge. Sir, Mr. Ridgeway Taylor, you cannot, as the way the law is written in the state of Michigan, carry a weapon of any kind. Do you understand, sir?
Yes, sir. Yes, Your Honor.
You cannot purchase, have in your possession, or use any type of weapon, sir. With that felony conviction from August 26, 2021, you are precluded, as the law is written now, from ever carrying a weapon. So try not, just don't do it, sir. You just get in more trouble. And it looks like these charges are centered around carrying a concealed weapon. Given though it's still a non-assaultive charge, even though this court has some concern, sir, that you had that felony conviction in August, and now here we are in December for a similar type of offense. Do you follow the court's orders? And that gives this court some pause and is wondering what would be needed so to catch your attention, and maybe, yes, as counsel alluded, this baby on the way would do so, but this court isn't sure, but this court is going to give you one more chance, Mr. Ridgway Taylor. Court is going to enter a personal bond, $3,000, personal bond, $3,000. No monies are needed to be released today on this particular charge, sir. Please don't pick up another offense or allegation or another charge, sir. You may not receive a personal bond in that case. I can't stress that any more than I can. Your next court date, sir. Give me one moment. I need a court date. But as I have a moment waiting for that court date, just don't pick up a weapon, sir. Don't use it. If you see one, just go in the opposite direction. Don't handle one, don't hold one, don't possess. You just cannot. You have that other felony conviction. You are precluded, sir, from, as the way the law is written, from carrying a weapon of any kind. Just don't do it. Just get yourself in trouble. Okay, court date, sir, and counsel. This probable cause conference on December 20th, probable cause conference December 20th, preliminary exam January 4th, preliminary exam January 4th. If there's nothing further, counsel, you're all set.
Thank you, Your Honor.
Attorney Bazzi.
Good afternoon, Your Honor. I have a Mohammed Ajrouj. DDC told me that he's going to be appearing in front of you today, so I just waited until the afternoon.
Let's see. What's the last name?
Ajrouj. It's AJROUCHE.
They did not make the list. He did not make the list this afternoon. He's not on my list this afternoon. You can check back tomorrow.
Thank you very much, Your Honor.
No problem, Attorney Bazzi. Have a good day.
You too.
Sir, at DDC, state your name.
Latrell Earl Robertson.
Thank you, Mr. Robertson. All right. Calling case number 2006032. People of the state of Michigan versus Latrell Earl Robertson. Counsel.
Janice Stevenson on behalf of Latrell Robertson. He waives the reading of the information and stands mute. We ask that a plea of not guilty be entered on his behalf. Mr. Robertson has been advised of his right to trial.
Not guilty plea will be entered on your client's behalf. I'm reading his way as to bond, but let me let you know, counsel, I have a capious $10,000 cash surety, $10,000 cash surety. Do you have any information as to this court's ability to modify that cash surety bond?
We do not, Your Honor.
All right, so with that being the case, Mr. Robertson, it appears that you missed a court date previously. When you missed that court date, sir, a $10,000 cash surety bond went into effect. So as it stands now, this court does not have the discretion to change that $10,000 cash surety bond. So that will continue. Your next court date is December 21st, 2021 at 8:30. That's a probable cause conference in front of Judge Williams. Preliminary exam January 5th, 2022 at 8:45. If you so choose. Anything further, counsel?
No, thank you, Your Honor.
You're all set, sir. Have a good day.
So what's my bond?
Bond is $10,000 cash surety. $10,000 cash surety.
Well, they don't want the same.
Good afternoon, sir. State your name.
Hudson.
Ahmad Hudson, calling case number 210-58276. People of the state of Michigan versus Ahmad Rashad Shabazz Hudson, counsel.
Janice Stevenson on behalf of Ahmad Hudson. He waives the reading of the information, stands mute, asks the plea of not guilty, enter on his behalf. Mr. Hudson has been advised of his rights, Your Honor.
Not guilty plea will be entered on your client's behalf. Formal reading is waived. I would say ask the bond, but again, I have a capious bond for your client, a $5,000 cash surety, $5,000 cash surety. Do you have any information of this court's ability to modify this cash surety bond?
I do not, Your Honor.
Thank you. Mr. Hudson, with that being the case, this court cannot modify and does not have the discretion to modify your $5,000 cash surety bond. What that means is that at an earlier court date, you missed that court date and this $5,000 cash surety bond went into effect. So that is what will continue. Your next court date is the probable cause conference, December 20th, 2021 at 8:30. December 20th, 2021 at 8:30. Probable cause conference in front of Judge Jones. Preliminary exam, if you so choose, January 4th, 2022 at 8:45. You're all set, sir. Have a good day.
Would I be able to get a cash, what's called a bond then, or no?
$5,000 cash surety bond is what you need to come up with. $5,000, sir.
Is that like $500 with 10% or something?
No, it's not. It's $5,000 cash surety.
So I can't go to a bonding company.
If they're gonna cover you for $5,000, you can.
Oh, I understand.
State your name, sir.
Maurice Friday.
Maurice Friday, thank you. Calling case number 216250501. People of the state of Michigan versus Maurice Friday, counsel.
Janice Stevenson on behalf of Maurice Friday stands mute, waives the reading of the information, asks the plea of not guilty, enter on his behalf. Mr. Friday has been advised of his rights, Your Honor.
Not guilty plea will be entered on your client's behalf. Formal reading is waived. Ask the bond.
Thank you, Your Honor. Mr. Friday is employed. It's a non-assaultive charge. He's advised us that he will abide by all court orders. All future court dates, not have any weapons in his possession. It's a non-assaultive charge, requesting release on personal bonds, Your Honor.
The court has heard the representation of counsel as to the community family employment ties of one Mr. Friday. Court would note that the underlying charge is non-assaultive on his face. Court further notes it does not have a prior capious history nor criminal history for Mr. Friday. No indication he is a flight risk or a general danger to the community. We're still in the pandemic. The court is inclined to give your client a chance. Sir, you're not to possess, use, purchase any firearms or weapons. Do you understand?
Yes. Come on here.
The court is going to enter a $3,000. Thank you. I heard you. $3,000 personal bond, $3,000 personal bond. No money is needed to be released today on this charge. Next court date is January 20th, 2022 at 8:30 a.m. Probable cause conference in front of Judge McConicle. Preliminary exam, January 27th, 8:45 a.m. in front of Judge McConicle, if you so choose. Again, January 20th and January 27th. Anything further, counsel?
No, thank you, Your Honor.
You're all set, sir. Have a good day.
All right.
State your name, sir.
Hannibal Bass.
Hannibal Bass. Okay, thank you. Calling case number 210-618-79. People of the state of Michigan versus Hannibal Edgar Bass III, counsel.
Janice Stevenson on behalf of Hannibal Bass. He stands mute, waives the reading of the information, asks for a plea of not guilty, enter on his behalf. Mr. Bass has been advised of his rights, Your Honor.
Not guilty plea will be entered on your client's behalf. Formal reading is waived as to bond.
Thank you, Your Honor. Mr. Bass is 18 years old. He is a senior in high school at this time. I don't believe we have any prior criminal history. He does have one child with no, Your Honor. The non-assaultive charge, we're requesting release on personal bond.
Court heard the representation of counsel as to the community family employment ties of one Mr. Bass. Court will note that the underlying charge is non-assaultive on this case. Court further notes it does not have a prior capious history in front of it for Mr. Bass. No indication he's a flight risk. At this time, this court does not have a prior criminal history for Mr. Bass. No indication he's a general danger to the community. We're still in the pandemic. Court's inclined to give your client a chance. Sir, you're not to possess, use, purchase any weapons or firearms. Do you understand?
Yes, sir.
Court's going to enter $3,000 personal bond, $3,000 personal bond. No money is needed to be released today. Next court date, probable cause conference, front Judge McConicle, January 20th, 2022, January 20th, 2022. Preliminary exam, January 27th, 2022, if you so choose. Anything further, counsel?
No, thank you, Your Honor.
You're all set, sir. Have a good day. State your name, sir.
Jerice Wright, sir.
Jerice Wright, thank you.
Welcome.
Calling case number 21045616. People of the state of Michigan versus Jerice Wright. Counsel.
Janice Stevenson appearing on behalf of Jerice Wright. He stands mute, waives the reading of the information, asks that a plea of not guilty enter on his behalf. Mr. Wright has been advised of his rights, Your Honor.
Not guilty plea will be entered on your client's behalf. Formal reading is waived as to bond.
Thank you, Your Honor. Mr. Wright has advised us that he does have an alternate residence. Therefore, he needs to have no contact whatsoever with the complaining witness in this matter or with the location of the alleged offense. Mr. Wright has also advised us that he has recently suffered a stroke, Your Honor, we believe within the last few days. Mr. Wright, 34 years old. He is employed at this time, Your Honor, does want to follow up on that health scare and is concerned about being able to keep his job. He has 4 minor children that he's supporting, Your Honor. Again, no contact at all with the complaining witness or the location of the alleged offense. Mr. Wright does request release on personal bond.
Thank you, counsel. Court has heard the representation of counsel as to the community family medical condition of Mr. Wright. Court would note that the underlying charge is serious and assaultive on his face. Court further notes it does not have a prior capious history, no indication that he's a flight risk. Court does not have a prior criminal history for Mr. Wright, no indication he's a general danger to the community, but this court does have some concern with the safety of Chantel Walk. Sir, you are to have no contact with Chantel Walk. Do you understand?
Yes, sir. I completely understand.
No
And I'll make
contact,
sure
means no contact, sir. Let me be as specific as possible. Nothing in writing, nothing verbally, nothing face-to-face, nothing through social media, nothing through a third party. Do you understand, sir?
Yes, sir, I do.
Let me give you an example. Let's say you're out at a public park or public space or retail store. You're thinking, I have every right to be in this public space or public park or retail store to do my shopping. And Miss Walk appears and she's at that same location, sir. I need you to remove yourself from that public space, from that public park or that retail store until she is no longer there. Do you understand, sir?
Yes, sir, I completely understand.
Court is going to enter $5,000 personal bond. No money needs to be released today. Court's also going to request a GPS tether. You can be released today. The court will give you until Monday, December 13th to get outfitted for that GPS tether. If you do not get outfitted for that GPS tether by December 13th, sir, a warrant may be issued for your arrest. You may find yourself incarcerated again. Do you understand, sir?
Sir.
The GPS tether is in place for 2 reasons. One, so yes, this court can monitor your whereabouts as you go about your day, because this GPS tether will have no restrictions. You can't go back and forth to work. You can pretty much go any place within the state of Michigan. You just cannot go any place that Miss Walk is. Do you understand, sir?
Yes, sir, completely.
And this court wants you to have a constant reminder. That GPS tether will be a constant reminder for you not to have that contact. That's what this court is hoping. Your next court date is a pretrial date scheduled for January 10th, 2022 at 8:30. January 10th, 2022 at 8:30 in front of Judge Garrett. Is there anything further, counsel?
No, thank you, Your Honor.
You're all set, sir. Have a good day.
You as well, sir. Appreciate you.
Good afternoon. State your name.
Justin Miller.
Justin Miller.
Yes, sir.
Thank you. Just got to speak up for me, Mr. Miller. Calling case number 2162509. People of the state of Michigan versus Justin Miller. Counsel.
Janice Stevenson on behalf of Justin Miller. He stands mute, waives the reading of the information, asks that a plea of not guilty be entered on his behalf. Mr. Miller has been advised of his rights, Your Honor.
Thank you. Not guilty plea will be entered on your client's behalf. Formal reading is waived as to bond.
Your Honor, Mr. Miller has advised us of an alternate residence. He therefore needs to have absolutely no contact with the complaining witness, Your Honor, or with the location of the alleged incident. Your Honor, Mr. Miller is 26 years old. He is employed, Your Honor, with a local plumbing company. He has graduated from a local high school. I don't have any capious history for Mr. Miller. He understands that he should have no contact whatsoever with this complaining witness. Mr. Miller would like to be able to return to work, Your Honor. He is on probation at this time, Your Honor. We bring that to the court's attention because we believe that minimizes the risk of flight. Mr. Miller remains under the jurisdiction and authority of a local probation officer. They know his whereabouts. He has been in touch with them. He's on track with his probation. We are requesting release on personal bond, Your Honor.
Thank you, counsel. Court has heard the representation of counsel as to the community family employment ties of one Mr. Miller. Court will note that the charges are serious and assaultive on their face. Court will further note it does not have a prior capious history for Mr. Miller. No indication he is a flight risk. This court does not have the information that counsel did, but does appreciate the honesty that Mr. Miller is on probation at this time. Does give this court some concern that he has these additional charges and still on probation. Court did read the investigator's report to help determine a reasonable bond in this case. Does appear that even though it is alleged that a two by four was in his possession, it does not appear that it was actually used. I don't have any information that it was actually used upon the alleged victim. So this court will take that into consideration. This court still does have concerns for the safety of Ms. Lakia Levon Griffin, because it is alleged that he did force his way into the residence. So the court does have to weigh that, as it also weighs whether the 2x4 was used, and it does appear that it was not in this particular case. Sir, you are to have no contact with Lakia Levon Griffin. Do you understand?
Yes, sir.
No contact means exactly that. Nothing face to face, nothing in writing, nothing verbally, nothing through social media, nothing through a third party. Do you understand, sir?
Yes, sir.
Let me be as clear as possible. Even though you may be in a public space, a public park or retail store, and I know you're probably thinking to yourself, you have every right to be there. It's a public space. But if Ms. Griffin shows up at that public space, public park or retail store, you are the person that has to remove themselves from that location. Do you understand, sir?
Yes, sir.
Court is going to enter a $5,000 personal bond, $5,000 personal bond. Court is going to enter GPS tether. No restrictions on the GPS tether. He will have until Monday, December 13th to get outfitted for that GPS tether so he can keep his job. But he will have to get outfitted by December 13th, 2021, which is Monday. If you do not, Mr. Miller, a warrant may be issued for your arrest. You may find yourself incarcerated if you do not get outfitted with that tether. That tether is in place for two reasons, sir. Yes, so this court can monitor your whereabouts. And two, hopefully as a constant reminder that while this case is ongoing, that you are to stay away from Ms. Griffin. Just stay away and you'll be able to get through this particular case. Your next court date is probable cause conference on December 22nd, 2021 at 8:30. Preliminary exam January 4th, 2022 at 8:45. Probable cause December 22nd at 8:30. Preliminary exam January 4th. If there's nothing further, counsel, you're all set, sir.
Your Honor, I would just say that Mr. Miller looks as if he's attempting to say something to the court. Mr. Miller, I would just say that the court has spoken with regard to bond. If you have a question about anything other than the conditions of bond, please save those until you have an opportunity to speak with counsel. If you have a question about bond, just about the bond, you can address that to the court.
Okay.
Just about the bond.
Okay. Well, I was gonna go to my mom's house, my mom's riverfront, my mom's other house. If you guys was concerned about where I was gonna be about the GPS tether, because I still had to report my agent.
Okay, thank you, Your Honor. I don't think we have any further at this time.
Nothing further. You're all set, sir. Have a good day. State your name, sir. Eric Brown. Eric Brown. Calling case number 210-623-68. People of the state of Michigan versus Eric Brown, counsel.
Janice Stevenson on behalf of Eric Brown. He waives the reading of the information and stands mute. We ask that a plea of not guilty enter on his behalf. Mr. Brown has been advised.
Not guilty plea will be entered on your client's behalf. Formal reading is waived. Ask the bond.
Thank you, Your Honor. Mr. Brown does have 3 children in this community. He is employed locally, Your Honor. He has absolutely no contact with the complaining witness in this matter. He's lived in this community for over 20 years. We're noticing that the date of the alleged incident at this point is about 6 or 7 months ago. Mr. Brown was not aware that the matter was outstanding. He certainly would have attended to it had he known that the matter was outstanding. Would abide by all court orders, Your Honor, have no contact with the complaining witness. I don't believe we have any prior criminal history, Your Honor. You understand the very serious nature of the charges. We've had the opportunity to briefly discuss that with Mr. Brown. We have every reason to believe that he'll be in court when he's supposed to be in court, that he won't have any contact with this complainant. We are requesting release on personal bond so that Mr. Brown is able to continue to work to support his 3 children, Your Honor.
Thank you, counsel. Court heard the representation of counsel as to the community family employment ties of one Mr. Brown. Court would know that the charges are serious and assaultive on their face. Court further note it does not have a prior capious history. There's no indication he's a flight risk. Court does not have a prior criminal history for Mr. Brown. No indication he's a general danger to the community. However, this court does have some concerns about the safety of Leah Britton. So no contact orders in place. Mr. Brown, you are to have no contact with Ms. Britton. Do you understand?
Yes, sir.
No contact means exactly that. Now, I do understand you have children in common. Counsel, I'll ask you, do you know if there's any type of parenting time or visitation order in place?
She can just have my kid. sorry.
I'm not aware of that, Your Honor. And I certainly believe that Mr. Brown is able to abide by any conditions of the family court with regard to parenting time without violating this court's no contact order, Your Honor.
Thank you. So what this court would say to you, Mr. Brown, is that you are to have no contact face-to-face or in person with the complaining witness, Ms. Britton. But if you need to exchange information and communicate via text message, that will be fine via text message as it relates to the exchange or transfer of children. I would advise you to obviously hold that transfer or exchange at a police station. At this time, though, any other form of communication face-to-face, that is not to occur. Do you understand, sir?
Yes, sir.
Through a third party, unless it's an attorney, that's not to occur, sir, unless it has something to do with your children. You all basically have nothing else to talk about. Do you understand, sir?
Yes, sir.
Now, even if Ms. Britton reaches out to you in any form of communication, asking you to come over, asking you to do something that may violate, to have contact with her, that may violate the conditions of this court, you are not to respond. Do you understand, sir?
Yes, sir.
If you respond, you may find yourself incarcerated once again, and you may not be released in that particular matter. This court is going to enter a personal bond, $10,000, personal bond, $10,000 in this particular case. This court did review the investigator's report. And upon reading it again, this court does have some concerns with her safety. It is alleged that your client used a closed fist and did hit her in the face several times. That gives this court some pause for concern for her safety. So a GPS tether will be in place. I will once again allow him to be released today so that he can keep his job. But by Monday, December 13th, 2021, he is to be outfitted for that GPS tether. Mr. Brown, if you're not outfitted for that GPS tether on or by December 13th, 2021, you will then find yourself in violation of the bond conditions and you may find yourself rearrested. Do you understand, sir?
But can I address something? Ain't no way I work in and out of town. That way I can like get that set for another day. Because I think I'm supposed to be in Fort Wayne, Indiana, around the 12th to the 14th of December.
Well, first and foremost, during most bond conditions, you're not able to leave the state, sir.
Oh, okay.
So that's first and foremost. You can't leave the state. Tell me more about you leaving the state. Why are you leaving the state?
I'll be working. My job be consist on sometimes be local and sometimes it be in and out of town.
If I can continue to ask your client some questions, Ms. Stevenson, what type of work do you do, sir?
I do epoxy floors for a commercial business. Journeyman
Epoxy floors?
Yes,
You're
sir.
a journeyman?
Yes.
You have your journeyman's card?
No, I do not have it on me.
Well, yeah, not on you, but you do have one. You do have one in your possession?
Yeah, I'm taking my class to get certified, but that's exactly what I do, though.
Okay, so you don't have a card or license yet?
No, not my license. I'm going through the classes within hands-on training of. I've been doing it for like 10 months, and he hands-on training us from there.
Okay. Well, sir, at this point in time, you're not going to be able to leave the state. Okay, so you're going to need to work that out with your class and or apprenticeship or employer to make sure that all your jobs are local while this case is ongoing. GPS tether, I'll make no restrictions, so you will be allowed to move throughout the state, but you have to stay within the state. Again, by December 13th, so that Monday, you need to be outfitted with that GPS tether. Next court date, probable cause conference, December 20th, 2021. December 20th, 2021. Preliminary exam, if you so choose, January 4th, 2022. January 4th, 2022. That's in front of Judge King. Anything further, counsel?
No, thank you very much, Your Honor.
You're all set, sir. Have a good day.
All right, thank you.
State your name, sir.
Daquan Turner.
Daquan Turner, thank you. Calling case number 210-62501. People of the state of Michigan versus Daquan Cortez Turner, counsel.
Janice Stevenson, on behalf of Daquan Turner, he stands mute, waives the reading of the information as to the plea of not guilty. Enter on his behalf. Mr. Turner's been advised of his rights, Your Honor.
Thank you. Not guilty plea will be entered on your client's behalf. Formal reading is waived. As to bond, and make sure you face us, face the camera when you're talking.
I will, thank you, Your Honor. Mr. Turner is 19 years old, would have absolutely no contact with the complaining witness, Your Honor. We've been given an address separate from the location of the alleged offense. Mr. Turner does live locally with a grandmother. He has a 6-month-old child. He does hold a GED at this time, Your Honor. I don't show any habeas history on, well, it's a fresh case. Don't show any habeas history for anything else either, Your Honor. Mr. Turner is requesting release on personal bond, no contact with the complainant.
Thank you, counsel. The court has heard the representation of counsel as to the community, family, employment ties. One, Mr. Turner. Court would note that the charges are very serious and assaultive on their face. Court will further note that it does not have a prior habeas history for Mr. Turner, no indication he's a flight risk. Court does not have a previous criminal history for Mr. Turner, no indication that he's a general danger to the community, except for this court does have concerns about Ms. Hicks' safety, Ebony Hicks, as well as that the allegations, if there's any form of truth to the allegation, it's alleged that Mr. Turner fired 5 to 6 shots at the complaining witness's vehicle. That gives this court some concern for the general safety of the community, given that anyone could have been hit or injured. It does appear the complaining witness was not hit or injured, but anytime a firearm is used and that firearm is discharged, this court has to pause and has to lean towards the safety of the community as well as the complaining witness, more so than the liberty or freedom of your client. Mr. Turner, you are to have no contact first and foremost with Ebony Hicks. Do you understand?
Yes, sir, Your Honor. Your Honor.
That means nothing face to face. That means, let me finish, sir. Nothing face to face, nothing in person, nothing in writing, nothing through social media, nothing through a third party. You can't have any contact with Ebony Hicks. Do you understand, sir?
Yes, sir. Yes, sir. I did not.
Even if she reaches, I know you chomping at the bit to speak, but I would advise you not to say anything at this time. You do have counsel. I'll give you an opportunity to speak, but let the court finish. Sir, even if Ms. Hicks reaches out to you in any form of communication, you're going to have to be rude to her, meaning do not respond. Do you understand, sir?
Yes, sir.
Also, let me try to make it as clear as possible and give you an example. Let's say you had a public park or public space or a retail store, and you're thinking to yourself, you have every right to be at that public park or public space or retail store to do your shopping, but guess what? Ebony Hicks shows up at the same location, sir. I need you to remove yourself from that location immediately. Do you understand, sir?
Yes, sir.
You are not to possess, purchase, use any firearms or weapons. Do you understand?
Yes, sir.
Tell me the employment situation of your client again.
Your Honor, it's our information that Mr. Hicks is, Mr. Turner is employed at this time, Your Honor. I think he may be doing some freelance work, Your Honor.
Thank you. There's going to be a GPS tether. GPS tether is going to be in place. for two purposes, Mr. Turner.
May I, Your Honor? I don't want to interrupt the court, Your Honor. But Mr. Turner, sir, at this point, I hope you do understand that the plea of not guilty has been entered on your behalf. At this point, we just need to listen to what what Magistrate Johnson is going to tell us with regard to your bond. This is definitely not the time for you to speak about anything that did or did not happen on December 8th of 2021. At this point, I'm advising you just to listen so we can make sure that we understand what the bond conditions are and that we abide by those bond conditions.
Yes, ma'am.
GPS tether will allow your client to be able to do his freelance work and keep any employment that he may have. I'll just keep it at that GPS tether. No restrictions. But in this particular case, since the firearm was used allegedly and that firearm was discharged 5 to 6 times, this court does not feel that a personal bond would be best, but a monetary bond in this particular case, $25,000, 10%, $25,000, 10% is what's going to be needed for your client to be released. And upon release, then a GPS tether, no restrictions on that GPS tether. This court feels that whenever a firearm is allegedly used and shots actually fired, thankfully, no one was hit or in this particular case, but it could have been a lot worse. And so thus the 10% provision. So hopefully he understands that he should not violate. If he does violate, he'll lose not only his potential freedom with being incarcerated, but also the monies that were put up for bail. Probable cause is December 22nd, 2021 at 8:30. Probable cause December 22nd, 2021 at 8:30. Preliminary exam January 4th, 2022 at 8:45. Nothing further, counsel. We're all set.
Thank you very much, Your Honor.
Thank you. Have a good day, sir.
It's fooling. Cameron, Aaron Hill.
Cameron Hill, thank you. Calling case number 210-625-030. People of the state of Michigan versus Cameron Hill. Counsel.
Janice Stevenson on behalf of Cameron Hill. He waives the reading of the information and stands mute. We ask for the plea of not guilty enter on his behalf. Mr. Hill has been advised of his rights.
The not guilty plea will be entered on your client's behalf. Formal reading is waived. Ask the bond.
Thank you, Your Honor. Mr. Hill is employed, Your Honor. The non-assaultive charge is 21 years old with no prior criminal history. We are requesting the court consider release on personal bond.
Thank you, counsel. Court has heard the representation of counsel as to the community, family, employment ties of one Mr. Hill. Court will note that the underlying charge is non-assaultive on his face. Court will further note it does not have a prior capious history for Mr. Hill. There's no indication he's a flight risk. In addition, the court does not have a prior criminal history for Mr. Hill. No indication he's a general danger to the community. Thus, this court is inclined to give your client a chance. We're still in the pandemic. Sir, you're not to possess, purchase, use any firearms or weapons. Do you understand?
Yes, Your Honor.
Court is going to enter $3,000 personal bond. $3,000 personal bond. No money is needed to be released today on this charge. Next court date, January 20th, 2022, in front of Judge McConicle for a probable cause conference. That's January 20th, 2022. Preliminary exam is January 27th, 2022. If you so choose. Anything further, counsel?
No, thank you, Your Honor.
You're all set, sir. Have a good day.
Thank you, Your Honor.
I think that's it, DDC. That's all I have.
Yes, Your Honor, you have a good evening.
You have a better one. Thank you, sir. Attorney Stevenson, thank you so much for your time.
Thank you, everybody. Have a safe Saturday and nice weekend, okay?
You too.
Thank you.